Another moment of shock has happened in the current retrial, and I'm gonna go through it today. And it was in regards to that mistrial request by Alessi, where he called out Brennan for asking improper questions, misstating, not asking proper questions. Asking improper questions on cross examination of Dr. Wolf, where he basically misstated the evidence, saying that the clothing of John O'Keefe had been scratched up on the floor where he was found.
You see other holes on the back of Mr. O'Keefe's sweatshirt?
It appears I see one hole.
Let me get a little closer so you can get a better look. I'll direct you to here. Do you see more than one hole in the back of Mr. O'Keefe's sweatshirt?
Yes.
As presented by Alessi, it was his own criminalist who made it clear that they made those cuttings, and his office was well aware of it. Brennan, I'm pretty sure, was well aware of it.
To Dr. Wolf, the ARCA expert, to try to make it seem like Dr. Wolf didn't do his job. You didn't account for these holes. How could you be a credible accident reconstructionist when you talk about some holes, but you don't talk about these holes? Knowing all along the holes that Attorney Brennan is trying to impeach Dr. Wolf on were caused by the Commonwealth's own criminalists as part of sampling. I don't believe one could come up with more misleading, misdirecting, elucidation of testimony than this on the key issue in the case. We have irrefutable, objective evidence, and I will state that it's more than interesting that none of these exhibits that Your Honor now has marked for identification were put in evidence by the Commonwealth. Isn't it some coincidence that these are the one, and the only one of the, with regard to the hoodie, the back of it's not in, all of the rest of them are, but these aren't. Your Honor, I think there is one and only one conclusion, in that this is intentional, that it is a matter of such significance and of such misconduct and intentional that it merits the sanction of a mistrial with prejudice.
Your Honor, my brief review of the lab paperwork and looking at the hoodie, it appears that I made a mistake. And so I think what should happen is there should be a curative instruction. There should be a stipulation. The court should instruct the jury that during Mr. Brennan's cross-examination, he asked Dr. Wolf about holes on the sweatshirt or holes on the back of Mr. O'Keefe's sweatshirt. And the parties agree the holes were made by a crime lab technician. This was done inadvertently but should not have been asked. The court should strike the questions and the answers. And you should instruct the jury there to completely disregard any questions or answers about the holes in the back of the sweatshirt. And the court should allow the defense to introduce the lab paperwork.
However, the judge decided to only give a jury instruction to basically say, yeah, this can be cured by a jury instruction and there's no need for a mistrial. To me, seeing all this, it was a travesty. Hi, I go by the name of Heinz. Thank you so much for tuning in for another video. This is Catch Up Court TV. Let's catch up with the Karen Read case. So there is no way to look at that decision any other way, because to me it feels like this is an unfair trial going. You cannot misstate evidence as a prosecutor. This is your role as a prosecutor. It even says on the ABA standards that the prosecutor should not intentionally misstate the evidence or mislead the jury as to the inferences it may draw. It was proven that that's what happened today. And I'm sorry, but watching that happen and the fact that it was as clear as day Obviously, Alice called this out and shown that they had full knowledge that this was the criminalist that caused those holes, not from the accident. But that didn't stop Brennan from making known to the jury that it was at the scene. And what makes it this bad, or in my opinion worse, is even with the jury instruction that was given to the jury to basically say that the holes was caused by the criminalist, it still didn't. They didn't say that. They didn't show that. It was very watered down. It was very weak.
Jurors, I appreciate your patience. Mr. Lessie, why don't you hold the exhibit up for the jurors, please? All right, jurors, that's the back of the sweatshirt that was shown to Dr. Wolf. Okay, thank you. Why don't you go ahead and put it back in the bag? So, jurors, I instruct you that those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt back on May 18th, 2023. Okay?
Like, I'm not even sure if the jury came off with the effect that the testimony was misstated. It was as if the prosecution had to be protected because of their own mistake. I don't want to look at and side-eye Bev for her decisions, but this is going to be, in my opinion, an appealable issue. I'm not a lawyer. I just want to put it out there. I'm not a lawyer by any stretch of the imaginations. I'm just a layman that basically has an interest in the law. And I did find two cases out there that that was taken to the Supreme Court and it was reversed. These two cases are all Commonwealth cases, and it's Commonwealth versus Daley. The first one, 2022. This case basically is on prosecutorial misconduct. The issue is whether the prosecutor's persistent presentation of the defendants as a crack cocaine dealing, drug and calling abusing thief, coupled with the prosecutor's invitation to the jury to consider the defendant's character and the prosecutor's complete disregard of the judge's explicit order to refrain from argument about the defendant's supposed guilty conscience, push the jury in a direction that proper argument would not have taken them. The defendant also contends that during closing argument, the prosecutor misstated evidence when she twice described the defendant as having admitted he stolen a knife. Finally, he argues that the prosecutor impermissibly adverted to evidence of his consciousness of guilt, although she had ordered by the judge not to do so. The prosecution failed to respond to discovery requests on this issue. And this is the main point here. It says the prosecutor misstated evidence. Contrary to the prosecutor's assertions, he told you he stole it. Those were his words. I stole it. I was grabbing food and I stole the knife. The defendant did not say he had stolen a knife, and the evidence does not justify such an inference. The sole reference to a knife during direct examination of the defendant, he testified that following the incident at about 7 p.m., he returned to the Salvation Army shelter, too late to get a bed for the evening. He attended to get something to eat, but he was told he had to leave the shelter. A police officer came in and told him to sit on the floor next to a soda machine. The officer found a knife on the defendant's person. It was not evidence from which it could be reasonably be inferred that the knife in the defendant's possession at the time he was detained, and apparently such had been stolen by him, and there was no other evidence from which this interference could have been drawn. So the point I want to get to is the fact that it was specifically noted in this ruling that nor was the impact of the prosecutor's improper final argument mitigated by the judge's instruction to the jury, issued at the conclusion of the argument, that referred only to the improper use of the defendant's cocaine conviction. the judge began by stating that there is one thing I want to correct about the prosecutor's argument, emphasis supplied. The ensuing instruction made no mention of prosecutor's misstatements regarding the knife, nor the impermissible suggestion that guilt might be based on his character as a thief, nor the prosecutors made improper allusion to the supposed evidence of the defendant's guilty conscience. By focusing on the cocaine conviction, the curative instruction may have appeared endorsed the rest of the prosecutor's argument. We are not persuaded that the general instruction informing the jury to consider only evidence introduced at trial and argument was evidence was sufficient to overcome prosecutor's misconduct, sufficient to defeat even a strong case for the Commonwealth. The prosecutor's misstatement of the evidence and inappropriate characterization of the defendant as a thief were errors objected by the defendant, and when considered in light of numerous other prosecutorial missteps and the absence of adequate curative instructions, require reversal. And it was reversed in the end. So basically, even though there was a jury instruction presented in this particular case to basically try and cure everything, to basically try and mitigate the error that the prosecution made there by eliciting a testimony that never existed, and you can't find proof of it, that was still reversed. So the point I'm making here is, if she gets a conviction out of this and this case goes to appeal, there is a really strong basis here based on the one of this case law. I'm pretty sure the appeal lawyers that Karen will get, if the guilty verdict comes back, I'm pretty sure they will find plenty more cases to argue the point. But this is the one case I could find in, like, I don't know, 4 hours of looking, and is the only one that I think is the closest one, because end of the day, though, those cuttings were never in evidence to begin with, and that's what Alessi masterfully shown, that the cuttings to the back of the shirt was not in evidence, and the jury did not even know about the cuttings, yet he continued to make comments in regards to the cuttings to Dr. Wolf. And to me, when you do something like this, it shows that they have no case. They have no basis to bring this, and the ARCA testing that was done was devastating for them, because it basically countered the evidence that was put in front of them. I'm inclined to think that if this case ends with a guilty verdict, that there are so many points that could be pointed out here for Karen Read to use to get a reversal. But we're back here for a new trial, and she'll be in jail. All of this, in my opinion, is, to me, what happened today is the biggest miscarriage of justice, in my opinion, because I am thinking of how the jury is going to unhear that. This case reeks. It stinks. It makes me angry to even do this, to even think about this, but I hope that the jury look at the inference of their saying that it was an error. I hope that they look at that and put it against the Commonwealth so badly that they would acquit Karen Read, because what happened today is really unfair. Anyways, that's all we have time for. Ladies and gentlemen, thank you so much for tuning in and listening to me rant about this case. Thank you so much for watching. Make sure that you let your friends, grandma, alien, everyone know about this channel. Like this video, subscribe for more videos that I have coming in regards to the Karen Read trial. I am following it, and I am doing a lot of videos based on my thoughts of the case. I also have another video that you can watch where I went through the ARCA testimony and gave my rant about the takes in regards to that testimony. So make sure you go check that out. You can click it. But yeah, I'm gonna leave it there. Thank you so much for tuning in. Take good care of yourself. Bye for now.